Well, hello, and how are you doing today? Well, come on in and have a seat because we got our returning guest, Eddie Craig, back on, and I'm real excited to have him back here again. And like I say, there's plenty of those Trump bars, so if you need them, it's all in the description box. You call or email me, get a hold of me that way. But other than that, let's go ahead and bring on Eddie. Eddie, how are you doing today?
I'm doing fine, and you?
Oh, I'm just enjoying this nice cool weather. This 104 temperature makes me want to jump right up underneath the ceiling fan for sure. So, well, anyhow, enough chit-chatting. We were talking because we had lunch again Saturday, and I was proposing a question to you about, how are we really going to make some good headway with, because everybody files lawsuits and they all just get dismissed out of hand. And you had a couple of really interesting takes on it, and I thought everybody would like to hear what you had to say. So go ahead and take the floor, and let's get shut and get going on this.
Well, tell me what it was you liked about the comments I made, and I'll expound upon them from there for the folks.
Well, you were talking about educating the people, and it really will not change until more people, such as juries, actually know what the laws are in order to just take some of these cases and just not even hear them, just throw them out saying this is garbage. And that was one of the main takeaways that I kind of got out of it. And that was the purpose of this channel, is to educate people on the laws like we did last week, just breaking down speeding and how those are being misapplied on a routine basis.
Yeah, and it's true. I've always held the belief that if we don't start this at the local level, it will never get fixed. The big wrench in the gear of their system is and always will be the jury. If the jury knows and understands the law, then they know and understand what the state is not telling them when they're trying to prosecute someone under that law. They know what's required, they know why it's required, and they know who it applies to and who it does not apply to. That's what knowledge of the law actually means, is that you have a complete understanding of how it works, who it is applicable to, because not all law is applicable to everyone. A good example is England is full of law, okay? But it only governs the English people. And depending upon what kind of law it is, it may only govern some of the English people that are engaged in a particular activity or occupation or something of that nature that limits the applicability of that law. Well, it works the same way here. Each state has its own set of laws, though they are more or less uniform across the board throughout the states. They're still individual to the states. You can't use a California law to prosecute someone for an offense committed in Texas. It just doesn't work that way. You would have to use the Texas law for that if there is one. So we always need to start locally with knowledge and training and understanding to educate the public on what the law is, what it says, and what it means. And that's what I've been trying to do ever since I've been doing my radio show. Here is what the law actually says versus what these people are telling you it means and how they're using it, both of which are wrong and are for the purpose of generating revenue for them at our expense. It is a gargantuan fraudulent activity on the part of the state and the locals to steal our money. And without that knowledge at the local level, they will be able to continue to get away with that every time, all the time. Until the jury starts saying not guilty, regardless of what the judge says, and regardless of what the prosecution presents, because the jury understands that law does not apply here, and the state has offered no evidence that it applies here, they're just alleging that it does and then trying to prosecute someone with it, then we're not going to convict them. We're going to find them not guilty every single time. Eventually what will happen is they will either A, stop enforcing those laws because they can't generate revenue with them anymore, or they will have to change the law to actually match what it's intended to do so that there is no question as to how the law applies, unlike how they're doing it now.
Well, the biggest problem is now is they're misapplying the law and just telling the jury what to think and that they need to get a prosecution. And most of the times, especially in some of the traffic court cases, they go in there and will deliberate for about like 5 minutes and come out, and you're just automatically guilty. They're more worried about going to lunch than they are about seeing.
And that's true, because they don't see how this affects them. Their day was ruined by having to come in and do this. They had to take time off work. They had to drive in town. They had to get a babysitter, et cetera, et cetera, et cetera. But this is the thing. That's also part of the public education, public responsibility for their government. Right now, the indoctrination level in the public schools is, don't worry about your government. It can take care of itself. It doesn't need you. So nobody cares. Nobody thinks. Everybody just says, well, surely they'll do it the right way. And that could not be further from the truth. These people do not care about right and wrong. They care about their bureaucratic power and where it keeps them, the power it gives them over other people. They don't care what the law says. If they did, they would actually read it. They don't care what you try to argue about it. It doesn't fit in with how they want it to be based in their own mind. It doesn't matter that they haven't read it to understand it. To them, this is what they were told it means, and that's all that matters. And they were told that by the very people in the system that want this status quo to stay in place.
You know, I've found after having a couple of jury trials that I figured, well, the jury is just too damn dumb. They don't know the law, and you're automatically going to be found guilty. So I quit asking for any type of jury trial and just started moving for a trial by a judge because I wanted him to make the legal determination, and basically it was going to have to hang around his neck. Of course, I've only had a couple of successful instances doing that. Generally, they're still just going to find you guilty all the way, no matter what. So that's kind of another problem. You know, it's kind of like, even though you bring your arguments into a court just for over a traffic ticket, I even asked the judge, I said, you know, I brought my paperwork asking where did I go wrong? And, you know, effectively, we had a little bit of a conversation, and the judge told me, he said every year all the judges had to go down to Austin to be told how they're going to, and, you know, that they had to be correct. And I asked him, I said, you mean like politically correct? And he said, yes. And I said, okay, now that we know that the system is broken, how do we fix it? And he looked me right in the eye and he said, it's going to take more people like you. That was a wake-up call to me, listening to them, how they're being forced to interpret law, whatever fits their little narrative. And even though you brought in everything that was completely correct, they still would find you guilty. And that was a little bit concerning, knowing that you couldn't depend on a jury because they had no clue and they didn't really care. And they're all mad, like you said, because they had to be there to start with. And then the judges are kind of forced into making these determinations because they didn't want, obviously, they didn't want me to set any type of precedent in that little old case because it'd have a ripple effect throughout the whole state of Texas.
Well, the thing is you can't set precedent in these lower level courts because there's always higher precedent of the higher courts that has to be overcome. You cannot set precedent at this level. All you can do is get the case dismissed. That's it. They can't make an opinion of anything. And therein lies the problem. Most of these prosecutions in the municipal and JP courts are rigged, as you just stated. They're rigged because there's been a predetermination as to how this court is to rule on particular types of cases, period. That is not justice. Never has been, never will be. But that is how the system is set up. what I was saying about those who are in the system who want them to do this way, that's rigging everything in their training, that's the Texas Municipal Education Center. That's the Texas Municipal League. Those are the entities that are training these judges in the justice and municipal courts to do the very thing you're talking about. They're the ones responsible. They are intentionally misusing the law to generate revenue because they know, just like an insurance company knows when they're collecting premiums from 1 million people, that only a handful of those people are actually ever going to file claims. Okay? That's how the insurance company makes its money, hedging their bet that they will get more money in than they will ever have to pay back out in claims. Well, these courts are exactly the same way. Their goal is to get in more money through fraud than they might ever be forced to pay someone who found out the truth if they lost. Because they will do their dead level best to bury the outcome of any suit where they wound up on the losing end.
That's correct. Now, what other type of solutions could you propose? You know, I mean, education is obviously one thing, but is there anything else that can be done that we're just overlooking or not doing?
There are several things, some of which are highly improbable and rather dangerous to us as it is. But it would still take an organized effort of the people of a given state to make it happen. Even then, there's no guarantee because they're having to rely on representatives who don't give a crap about them. They give a crap only about what their lobbyists pay them to care about. So as long as we have lobbyists, and we do, the transportation code is being enforced the way it is in every state for one reason and one reason only, and that's revenue generation. Consider this. This is the scenario if it was enforced correctly as it is actually written. There would only be a small number of people who would have to pay the yearly renewal fees for licenses, registration, inspection, so on and so forth. There would only be a minimal, those same people would be the only ones required to carry liability insurance as mandatory. Okay? So that would cut down on the amount of revenue the state generates in the area of transportation, registration, licensing, insurance, inspections, and everything by several $100 million a year. Okay? Several $100 million per year if they enforced it the way it's written. The way they've got it arranged, however, and the way they're doing it is compelling everyone to participate in this program, even though it does not apply to them. Thus, their revenue generation goes up by several $100 million per year. Across the entire United States, this is a $9 billion plus industry a year. $9 billion between all the 50 states.
You know, there was a in New Hampshire, and I should have sent this over to you earlier to let you take a look at it, but it was in 2018, New Hampshire had it on to vote in where they were going to eliminate driver's license and insurance. And I've got the document. I'll send it to you.
You're talking about a legislative enactment.
Yes.
They weren't going to do away with it. They were going to limit it to its actual purpose.
Well,
they were going to distinguish between those engaged in a business occupation or something of that nature.
Commerce.
Profession or occupation is the proper way.
Yeah.
A business, profession, or occupation.
Right.
And limit the license only to those that were required to have it. And
That's
yes, I've
correct.
seen that proposed bill.
Okay,
the thing about it is they don't need it. It's already written that way. Just nobody understands it because no one's bothered to dig into it deep enough to put all the puzzle pieces together. At least no one's ever done it like I've done it here in Texas.
Right. No, you're exactly right. They were going to distinguish between who is a traveler and who is a driver, which are legal terms of art, because a driver is a commercial in a commercial application.
Well, it's not just driver. There are three terms that are very applicable here: carrier, operator, and driver.
Right.
Carrier is the profession, okay? As in someone that runs a business like a trucking company or something of that nature, who owns the company and everything being used to operate that business. An operator can be the same thing as the carrier if they're actually someone that's using the vehicles and performing the same work that the profession is engaged in. So an operator and a carrier can be the same person. And the same person can also be a driver if that person is the one behind the wheel doing the actual work in the occupation of driver. So it's possible for one person to be all three things. They have their own carrier company registered and licensed by the state. They have an operator's license to carry on such a business within that state. And then they have a driver's license to act as a driver in that occupation and profession in the state. Okay?
Right.
It is possible. It's just not what is actually happening here. Okay? They have taken everybody in the general public and said, if you get behind the wheel of a car, you're in a motor vehicle. And that is an absolute false representation of the law. The law in Texas very clearly states that a vehicle is a device that is self-propelled and can be used to engage in this activity of transporting persons or property or drawing persons or property upon the highway. Okay? Well, can has a very distinctive meaning when it comes to law. If you look it up, you have to use the common English, but the one definition in common English that matches what it means in law is authorized by law. Well, a vehicle can only become a motor vehicle if it is authorized by law to engage in the activity of transporting persons or property or drawing them upon the highway. And the only way it can be authorized by law is if it is registered and insured and licensed as a motor vehicle for use by an operator or driver who is also licensed to engage in that particular business occupation within the state. But what they all neglect to pay attention to is that every one of these statutes within the Transportation Code falls under Article 3, Section 35 of the Texas Constitution, which says what the title of a bill must contain before that bill can pass through and be legislatively enacted. And that bill must contain the single subject that governs all the statutory schemes within that bill. And here in Texas, the title of SB 971, which is the bill that was put in place in 1995 here in Texas to recodify all of the various legislative statutes from diverse codes into a singular code called the Transportation Code. And in the title of SB 971, the bill that did this recodification, it clearly states that the subject, the single subject to which all these statutes apply is transportation. And transportation, by definition, is the movement of persons or property for compensation or hire by a carrier. Now, that term is not defined. Transportation is not defined in any Texas statute. But Chapter 311 and 312 of the Texas Government Code makes it very clear that as a term of art, or a word of art, which is what transportation is, it is to be given the actual meaning used by experts in the art, profession, or occupation to which the term applies. Now notice what it says. The art, the profession, or the occupation to which the term applies. Thus, all terms of art can be concluded to be representative of an art, a profession, or an occupation. It has nothing to do with general public activities. It only has to do with a specific art, a specific profession, or a specific occupation. So they cannot say that all the statutes within the Transportation Code do not have a commercial nexus, because that is exactly how transportation is defined. We've got several cases here settled by the Third Court of Appeals incorrectly, and they're all Perkins v. State. Okay? Perkins has like 7 cases. And in each of those cases, the Third Court of Appeals refused to read and apply Article 3, Section 35 to their interpretation of the title of SB 971. Now, granted, I did not see the paperwork Perkins filed in his defense in these cases. All I got to see was the opinions rendered by the Third Court of Appeals. But the Third Court of Appeals erroneously and idiotically and incompetently stated that the word transportation is nothing more than a title that fits on the front page of the first page of the code in which it's contained. And that's not true. It is in the title of the actual bill as being the single subject to which all statutory schemes within that recodification must adhere. And the Texas Supreme Court has ruled numerous times that the courts cannot ignore the single subject matter clause, and yet that is exactly what the Third Court of Appeals did. In every opinion they rendered, saying that the word transportation was just a word in the title of the code, and they didn't differentiate between title as in title of the bill versus title of the actual publication. But the inference is they're talking about the title of the publication because they never used the word bill. And since they never used the word bill, it would be obvious to me they never bothered to read the bill that created that frickin' code in the first place. So as a judicial body, the Third Court of Appeals is utterly incompetent. Every judge on it. I've met the judges personally on the Third Court of Appeals. The one female judge up there, I can't remember her last name. It starts with a D, but she had a DUI. She was arrested for DUI. She shouldn't have even been appointed to the Third Court of Appeals. But they swept her DUI under the rug and appointed her to the Third Court of Appeals anyway. This is the system covering its own in order to propagate the lies and the fraud that they're committing. You now owe us a favor, Judge, because we protected you. You're going to protect the system and the status quo. Every case you get will be protected from challenge to the best of your ability. And if you can't do it, when it gets to us, we will do it.
Damn. What type of recourse as, people in this republic do we actually have against something like this?
You mean other than the one covered by the Second Amendment?
Well, yeah, because that's the ultimate, but...
Well, Rule 1, you will never, ever change a broken or corrupt system from within.
Right.
Will never, ever be done. So saying that you're going to become a lawyer to fix these problems, you can forget that. That will never, ever happen. You cannot fix it from within. It's impossible. Okay? You can't fix it any more than a broken machine can repair itself.
Right.
So, given that, what are our options? Well, we make it unprofitable, beginning with the people sitting on juries. We educate the public. We get them in the know so that they know how this stuff works and they can't be misled and lied to anymore. Why do you think it is when you go in and you do jury selection that the people that show up are the lowest common denominator for IQ? You think they randomly chose this jury? They didn't. They chose this jury based upon the demographics of the voter rolls. Not the voter rolls in their entirety, but because they wanted to get the people who were most likely to be led astray and willing to go along to get along with what the system wants.
Right.
Or you have people that are involved in the system on your jury. You'll have other attorneys, for instance. You'll have cops, for instance.
Mm-hmm.
People who have a vested interest in making sure that they get to keep their power.
Yep, I've seen that firsthand. I actually called down. I was going to speak to the chief of police and the secretary. There was an assistant there for the secretary. I said, well, where's the secretary? Oh, she's on jury duty. I'm like, what? You know that there was a conflict of interest with that right there, that are in there to protect the system.
Well, everything they do is a conflict of interest. Every single thing they do. There is no way you can go into a court that is paid for by money laundering, which is made possible by the fines they steal through this fraud, in order to do what it does. And let me explain the money laundering comment. You've all seen in the movies how money laundering works. You collect money from an illegal means. You put it in all these other places. You invest it in these businesses, or you take it in as cash payments taken under this business name or this business name or this business name, and you send it through there. That business deposits into the bank, and then it goes into the bank, and then when it comes out the other side and you withdraw it from somewhere else based upon some payment issuance from that company after that money's been deposited, the money comes out the other side more or less clean, so to speak.
Mm-hmm.
Okay? That's money laundering. When you cover up the origin of the money so that it can't be traced back to the illegal activity, and then you collect it on the other end, more supposedly legally separated from its origin. Okay, that is money laundering. So let's look at how the municipalities and the county courts all do it. They get paid by either the county or the municipality, who, by the way, gets to keep 50% of any fines collected in these prosecutions, plus 100% of any extra fees that are attached, such as court costs, jury costs, warrant fees, et cetera, et cetera. They get to keep 100% of those, and they get to keep 50% of the fines. Now, that money, by law, that's collected in the fines has to go into a specific local account, which is road and bridge. Okay? So it goes into either the municipal road and bridge account, or it goes into the county road and bridge account. So once it's done that, okay, they go and they take money from some other account that belongs to the city or the county, and they can now take money that would have had to have been reserved for road and bridge and reallocate that to the account that is used to pay the judges and the prosecutors. So they take money and put it in the road and bridge. Then they take the money they take from us, they put it in road and bridge. Then they take money out of the general fund that would have had to have gone to road and bridge if that money wasn't collected, and reallocate it to the judicial fund to pay for their courts and their prosecutors. It's money laundering. It's the exact same thing. Put money in this account so that we can then filter things through these other accounts, so that the illegally gotten money is now separated from the money we pay out to the source of the illegal activity to begin with. It is absolutely 100% money laundering, because that money that they no longer had to allocate from the general fund into road and bridge can now be used to pay the judges and the attorneys that stole it in the first place.
Damn it. Wow. I don't even know how to really respond to that. I mean,
Well, there's not really a response to be had. It is right there in the law what they're required to do with this money.
Mm-hmm.
Yet they're not working for free. We know they get paid. So how do they get paid? Well, if you actually do a request for financial audit on the accounts and you ask for where this money goes, you will see how it works. The money is taken and put into a separate account. That's an absolute given. But what they never tell you when you challenge it as being a conflict of interest, because their excuse is, well, they're not paid with the money they stole. The money they take goes over here. It doesn't go back to them. So you can't say they're prosecuting you to line their own pockets. Like hell, you can't. They launder the money through that account, so it comes back out over here in this account, and the people paying them haven't lost anything. They've gained profit in the road and bridge because what they've stolen, it far exceeds what we're having to pay them out of the general fund.
Wow. So even if you did the information request, they're going to deny what they're doing is illegal.
Well, if you challenged it directly, yes, they would deny it. But if you showed that this money goes from here to here, and then they use money from a different account to pay these judges, but never allocated any to road and bridge, okay, or at least less than they would have had to have allocate without that money that was stolen, it becomes extremely financially obvious. They can't hide that.
Right.
But they can ignore it, and that's exactly what they've done.
So you can't even really get any recourse going that route either then.
The only way that we're ever going to fix them with a court is to do the same thing to them that was done relative to the failure to provide legal counsel during the magistration. There's a United States Supreme Court case directly challenging Texas magistration process. The United States Supreme Court ruled that what Texas was doing was absolutely unconstitutional because Texas was declaring that the magistration process was not adversarial, and therefore the accused was not entitled to legal counsel. Well, somebody finally challenged that. And the United States Supreme Court took it up, went through it, and stated very clearly, oh, yes, it is adversarial. And because it's adversarial, these people had a right to legal counsel, and you didn't let them have it. You didn't even give them the opportunity to get any legal counsel. You just held them in jail, brought them to this process, did what you did, and then either put them up for bail, put them back in jail, or put them out on a PR bond. But regardless, when they stood before that judge, they did not have assistance of counsel. That's a constitutional violation of their rights. Well, what the courts in Texas and every state really is doing is exactly the same thing. Like, for instance, Texas law very clearly states that, once again, you are entitled to an examining trial regardless of the level of the charge levied against you, even Class C fine onlys, not just felonies like the courts are trying to read the statute. Because their reading conflicts with numerous other provisions of the Texas Constitution and the Texas statutes on the Code of Criminal Procedure. Chapter 21 makes it very, very clear that not only do they have to have an information to prosecute you and invest a court with jurisdiction, which these municipal and JP courts don't use. They only use the complaint, which is absolutely illegal and unconstitutional under Texas law and Texas Constitution. But they completely ignore the examining trial process where probable cause is to be determined. In other words, you're being faced and prosecuted at trial with no probable cause determination having ever been made. None. Right. They are simply presuming you are guilty and moving forward with a trial. That, too, is unconstitutional. Because you have a right to that examining trial, because you have a right to that determination of probable cause. Not only that, when you're pulled over in Texas for a traffic offense, let's say, there has to be two probable cause determinations made. One, was the initial seizure without a warrant constitutionally allowed? In other words, was the seizure by the cop in stopping you constitutionally authorized? And if so, is there statutory schemes backing it up? Now, if there was probable cause to make the stop, now we've got to determine whether or not there's probable cause to believe you actually committed the offense that is actually alleged. So in that instance, there are two requirements, because by law, and Constitution, any warrantless arrest is considered unreasonable on its face. Therefore, the arrest should be challenged until the state proves the arrest was reasonable, which they can only do with a probable cause determination.
Okay.
Yes, the officer had probable cause to believe an offense was being committed. Okay, fine. Now, is there probable cause to believe the person the officer is accusing of committing the offense actually committed it? Yes or no? Well, yes, there is. Okay, so both probable cause determinations have been found. Now the court does what it's supposed to do in the examining trial, seals up the records, and sends them to the clerk of the court having jurisdiction, who is then required by law to send it to a grand jury, not to the court for trial. They're required to send it to the grand jury. Well, indictments in Texas are also still mandatory under Texas law for any level of criminal offense, including fine-only offenses. But they're not doing it. They're not prosecuting you in these courts with an information which is required by Constitution and by law, and they're not prosecuting you under an indictment, which is required by law. The Constitution says only an indictment or information invests the court with jurisdiction. That is something the courts themselves cannot overturn, and yet they have. They have rendered opinions that say they don't have to have an information in these lower courts because the legislature wrote a statute saying that in these lower courts, or at least in the municipal court, the prosecution will be done by the city attorney. There's a problem with the legislative attempt to grant that power to a city attorney. It's unconstitutional. Article 5, Section 21, or 12, 17, and 21 are the three that would prove it to be unconstitutional. The power to prosecute a criminal offense in the name of the state within Texas is specifically granted solely to two elected officials, the county or district attorney. No one else. So their office is the only offices that can prosecute criminal offenses in the name of the state. The legislature has no authority to supersede the Constitution and create a new form of prosecutor in the form of the city attorney and invest them with the power to do what only the county and district attorney can do. It's constitutionally prohibited as a delegated power. Not only that, the statute they're attempting to use to say they justified it is taken directly from the Texas Constitution, where the Constitution authorizes the legislature to create other courts by statute. But it does not grant the legislature the power to create other prosecutors by statute. Only other courts as needed, but not other prosecutors.
Right. Well, I'll just ask this quick question, and I know we're going to be running out of time because you can expound on it so deeply. But say you're in the middle of this process, could you immediately say this is a constitutional violation in order to get the proceedings stopped against you, or they're just going to go ahead and just give you the railroading?
If you're in the middle of this, you're already too late.
Right.
This is why I tell my class the same thing all the time. Every class, the same thing. Everything we do in a case, we do in writing. Now, in writing doesn't simply mean sit down and make the argument that the Constitution says you can't do this under this article, because they're already ignoring that article.
Right.
You haven't made an argument that convinces them that they're wrong, because they already think they're right in ignoring it. So they're not going to even look at it from that perspective. I've got someone I'm trying to help with her case right now that just wrote a motion herself that's exactly what she did, and it's not going to help her because they're already ignoring everything she put into it.
Right.
And the problem there is that in my seminar material, there is a separate constitutional challenge to every single thing I've talked about so far, to every single thing. And they're all within their own motion. They are not put together in one big motion because each of them alone is a big motion. And why is it big? Every one of my documents that does a constitutional challenge is in excess of 30 to 50 pages. And the reason for that is because I believe in a better mousetrap. I put in every single constitutional provision and statute that proves the original stare decisis opinion that made this grievous error of constitutional interpretation is dead frickin' wrong. If it's right, here is all the law and constitutional sections that opinion conflicts with. And because it is in conflict with all of these things, Article 1, Section 29 of the Texas Constitution under our Bill of Rights says it is null and void. That opinion is as worthless as a used piece of toilet paper for blowing your nose.
Okay. Well, let's speak about your class real quick and how people can sign up and get educated so that they can start learning all this stuff that you've been railing on for, shoot, I don't know how long you've been doing it, but I know it's been a really long time. So let everybody know how they can start following you and get into your classes.
Well, I do a show on Monday nights from 8 to 10 p.m. Central Standard Time on Rule of Law Radio, and you can get there by the two websites, either the Logos Radio Network or the ruleoflawradio.com website, and clicking on the listen link that appears on either of those sites, and it will take you into the live stream. It is a call-in show, so you can call in and ask questions, and it doesn't really matter what state you're in. The general principles of due process operate the same everywhere. The only thing that will change is when we're talking about a specific statutory scheme. Generally, I can look it up pretty quick, even while I'm on the air, and tell you what it says and help you understand what it says and what it means. Now, that will not be the end of it, because at that point, you're going to need to dig into it a lot deeper, because no single statute stands alone. There will always be more than one, that's called in para materia, that deals with the same subject as that statute does. And they all need to be read together. Now, besides the two sites for listening to the radio show, I've got a legal blog at taooflaw.com, which is TAO-OF-LAW.com. That's my WordPress blog. I've also got my Tao of Law, TAOOFLAW, all three separate words, on YouTube as a channel, which I gave Scott the link to it yesterday in an email, so he should be able to post it up with this video when it goes up. But on there, I'm going to start doing short videos that discuss little pieces of this stuff. And some of them will have to be multiple videos in a series, because as you can tell, there's a lot to this. It isn't just one simple thing you can go to, point at, and say, here you are. No. If you look at one thing, guaranteed there's going to be at least 3 or 4 other things, if not a whole lot more, you're going to have to look at before you have the complete picture to make an argument with. And that's what I teach people to do. Make a complete picture. Document it in writing. Use that to fight your case. Most of the cases I help people with using my paperwork get dismissed. For those that don't, they generally win on the appeal, if they get an appeal. Some people just throw up their hands and quit. They don't follow through on the appeal. But it is imperative that you be prepared to go the whole 9 yards if you start this fight. And you better know and understand what you're doing when you do it. If you don't, they're going to walk all over you. And all that's going to do is make you want to give up, and make everybody you talk to about it want to give up before they even start. And that is where we are failing each other. Somebody always wants somebody else to do it for them. That doesn't work here. Your attorney will never do it for you, because the attorney has a status quo to maintain. He can't make money if you can do it yourself, and he can't make money if you show him you know more than he does. So the attorney will never, ever do the things that I will show you to do. Never.
I agree 100% on that. And it's like I've told people all the time, these are your rights. You have to defend your rights. I have my rights. I'll defend them, but I can't defend your rights for you. You have to defend them, but you have to know what you're doing. And I'm glad you got that YouTube channel up and going now. So I encourage everybody to go subscribe to it. It will be in the link. In fact, it's going to be the very top link in the description. So you can click on that, sub to his channel, and start building up his channel. And you're going to start getting a lot of material straight from the horse's mouth. Of course, I'll always enjoy having Eddie on because we can kind of go back and forth on a couple of things. But by all means, subscribe to his channel. And if you get a chance and you need to talk to him, you could call in to Rule of Law Radio on Monday nights, 8 p.m. Texas time at rulelawradio.com. So that's another way you can kind of get some information and start learning exactly the things that he's been talking about and teaching. I know at least since 2014 because I used to attend his classes down there.
2009, actually.
Oh, well, you've been doing it since 2009. I just started going down there to 2014 and started, listening to him live and really starting to get a good understanding of some of this stuff. But it is deep, and I'm not going to lie about that. So, once you know this stuff and you get a good understanding, then you are mentally prepared, and that's 90% of the battle. Of course, you're going to have to follow through with a lot of paperwork too, but that's just only going to make your case. You can't verbally argue it. It's like you said, you have to put it in writing. So with that, do you have any comments you would like to make before we have to go ahead and close on out?
Yeah, on the YouTube channel, I've only got one video up right now, which will show you basically what the online class sessions will look like. All the online classes are recorded, and you always have access to and can download the class videos for the subscription period you're in. The class is by monthly, by yearly or yearly subscription with discounts for that. But I charge the same thing for the classes I charged when I was down at Brave New Books. And it actually works out where every time there's a fifth class in a month, you're getting a free class compared to how it would have been at Brave New Books. But in any case, on that YouTube channel, there will start to be short videos, 15, 20, 30-minute videos that go into some of this stuff. And then longer than that, I will start doing them in a series. I want to get an OBS layout made for doing that particular type of online video for you guys. But there is a video there showing you what the class videos will look like and how they work. But you can go and subscribe to the classes at either of the logosradionetwork.com website or the ruleoflawradio.com website, and you can subscribe to the class there.
Perfect. I encourage everybody that,
Oh, and one of the things, Scott, there is a Patreon link on the YouTube channel as well if anybody wants to help support my efforts through Patreon.
Well, great. I'm glad you got that out there. And this is how, supporting him is how he is actually making his living right now. So by all means, do what you can if you're able to subscribe and help support the work that he's been doing for a very long time and continues to do. So we have to support each other. This is what it's all about. That's why I want him on here. So y'all know that you have people like Eddie that will show you what you need to do. We just have to support him and help him so he can continue his work, because I've seen his studio over at his house that he's staying in right now. And let me tell you, it blew me away. I mean, he's got 3 curved screens up, another video monitor. He has a computer the size of a big old suitcase that weighs more than I do, 200 pounds. He was like, I bet that computer weighs more than you. I was like, you think? He goes, it weighs 200 pounds. I was like, oh, yeah, it does. I weigh $180. I was like, holy shit, that's big. So, but He's got a lot of time, a lot of hardware invested in this to put this together. It's not a simple process. He's the one that even showed me how to, he called me up. We talked Saturday. He goes, you want to improve your audio content quality on your channel? I was like, well, yeah. He goes, well, you need to do this, 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 and this. I was like, holy smoke. My eyes started spinning. And I said, well, I'll just come over. And so I did. Went over and took a look at it. And like I say, he has it's quality production video that he's putting out, bar none. So if you got it, the opportunity, help support him and his work, get into the class, start learning this, but just start getting engaged no matter what level you're at, because it's like he said, we have to start educating ourselves and others, because it's up to us to correct this broken system. It will not be done from within, and you can certainly bet on that. Other than that, you know the drill. Get engaged and stay frosty. Donald Trump is a fucking genius.